Hi, I'm Danny Harlow. This week's Webinar Wednesdays, we are discussing the responsibilities of an executor. Here are the steps you may be expected to perform as an executor, but keep in mind that this can be very depending on the state in which the decedent lived. So number one, collect the death certificate and organize estate planning and other legal documents. Number two, file the last will and testament with the court as required by the local laws. In some states, this must be done in person with a certain time period. In addition, if the decedent owned assets in multiple states, then this process must be required in multiple states. Number three, take an oath. After the court validates the will, you will appoint an executor who is typically the person or entity nominated in the will. To be approved, the executor must agree to faithfully fulfill the decedent's wishes, as outlined in the will, and abide by all applicable fiduciary laws and probate court rules. In an executor approved, the court will typically issue a formal document, sometimes referred to as a letter of testamentary. That document that the executor authorized. These letters give the executor the legal authority to act on behalf of the estate and are used to interact with third parties, such as financial institutions and state agencies. Number four, notify interested parties. In most forms of probate, the court will direct the executor to formally notify all those individuals that may have an interest, whether financial, legal, or otherwise, in the decedent's estate. This typically includes the decedent's heirs, financial institutions, insurance companies, creditors, government entities such as Social Security Office and DMV, for example. Number five, establish bank accounts for the estate. Because an estate is a separate legal entity, the decedent's individually owned accounts must be transferred into estate accounts. The executor is responsible for establishing a tax ID for the estate, properly opening these accounts, funding them, and prudently managing them throughout the course of the estate administration. With these accounts, the executor can receive any outstanding funds owed to the decedent and pay bills. Number six, post bonds if required. State law or the will itself may require an executor to obtain a probate or fiduciary bond, which serves as a form of insurance, primarily to protect the estate beneficiaries in the event of an executor does not properly fulfill their duties and obligations and cause financial harm to the estate. A probate bond is purchased by the executor and typically reimbursed by the estate. Number seven, maintain real estate and other estate assets. The executor is responsible for maintaining and protecting all estate assets until the estate is fully distributed. In the case of real estate, this includes properly maintaining the property and insuring the property as well. Number eight, create and file an inventory of the estate assets with the courts. In many states, an executor is responsible for submitting an estate inventory that details all assets that comprise a decedent's probate and potentially non-probate assets. This may include assessing safety deposit boxes and digital assets too. The usual practice is to engage a professional appraiser to value the decedent's tangible personal property. Number nine, you gotta file tax returns for the decedent and the estate. A final personal income tax return for the decedent for the year of death, federal and state estate and inheritance tax returns, and an estate income tax return for all income received by the estate while it's open may be required to be filed. Number 10, pay the estate's debts and taxes. While laws differ by state, the costs to settle an estate are the first to be paid. These typically include professional fees such as legal fees, executor fees, and the cost of public filing fees. Next are funeral expenses and taxes, with all the other claims, credit cards, utilities, etc. following those. Careful records should be kept and receipts should always be obtained. Number 11, resolve creditor claims. It is not uncommon for someone to die with outstanding bills, debts, or contractual obligations. An executor is responsible for evaluating these claims and, if valid, pay them. However, if an executor believes the claim is not valid, they may have to resolve or settle the claim or even litigate it if necessary. Number 12, distribute assets to beneficiaries. Executors must be certain that all estate debts, including outstanding bills, income, estate taxes have been satisfied before making a final distribution of estate assets to beneficiaries. In some cases, partial distributions can be made, provided the executor is confident sufficient estate assets remain to satisfy any outstanding liabilities. Number 13, wrap up the estate to close out the probate process. Prior to the complete distribution of assets, it's common for an executor to prepare an accounting and a receipt and release for each beneficiary to sign. Number 14, exhale. Take one deep breath, the work is done. In some cases, beneficiaries may have to wait months, if not years, to receive a distribution from an estate, depending on the complexity of the estate's assets, potential liabilities, and the timeliness of state and federal agencies like taxing authorities. As an executor, you may bear the brunt of any ear from frustrated family members who are waiting for an inheritance, even though the settlement time may not be within your power to control. This is simply a high-level view of probate and estate administration. When it comes to estate laws, each jurisdiction can have its own probate requirements. If you agree to take on an executor role, consider working with an attorney and financial professionals who understand local rules. If you'd like to learn more about how Harlow Wealth Management can help, call us today at 800-782-2136 and set up a complimentary 15-minute appointment.